Your Honor, we're here in the matter of the State of Ohio versus Michael D. Brown Sr. There are three cases before the court. The most recent, case number 25 CR 000089, will be before the court on the 20th of May, with the jury having found Mr. Brown guilty.
Right off the bat, guilty on 2 counts of first-degree rape. And here's the kicker: in Ohio, that's not just a slap on the wrist. We're talking life-changing consequences, literally.
As charged in a 2-count indictment, both counts being that of rape, felonies of first degree in violation of 290702A1B. At the time, the court ordered a pre-sentence investigation report along with the victim impact statement. Those having been afforded, we are here for sentencing in that case. The victim and her family are present in the courtroom. I am told that they do not wish to address the court at this time. The court has heard relevant testimony. We do have 2 other cases, 23 CR 1007 and 22 CR 1381, for which there are probation violations pending.
Interesting move here. The judge tosses out the probation violations. Why? Because when you're already convicted of something this serious, those lesser violations basically don't matter anymore. It's like throwing away a parking ticket when you're already facing life in prison.
All right, on the latter 2, the 1007 and the 1381, I'm going to dismiss those probation violations and terminate his probation. Before we get to the sentencing, I'm going to go through the explanation of duties to register as a sex offender, read them to you, Mr. Brown, and ask you to acknowledge them, that I read them to you by signing the document. The county of conviction is Lake, 25 CR 89. 2 counts of conviction under 2907.02A1B. Michael Delmar Brown Sr. You have been convicted of or pleaded guilty to a sexually oriented offense or a child victim offense as defined in 2950.01, and you are a Tier 3 sex offender. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporary domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in the calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or an aggregate of 14 days in the calendar year. Employment includes volunteer services.
And this is huge. Being classified as a Tier 3 sex offender means lifetime registration, reporting every 90 days, and 0 chances to fly under the radar. Quick question for you guys: do you think lifetime registration is fair, or should offenders get a second chance after decades?
You are required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of initial registration, you are required to periodically verify your residence address, place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, and/or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered, and to the sheriff in the county in which you intend to reside. Establish a place of employment and/or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You are further advised, in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to a criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you most recently registered. Depending upon your designation, you are required to comply with all the above described requirements for the following periods of time. As a Tier 3 offender for your lifetime with in-person verification every 90 days. Since your expected residence address is in Lake County, you shall register in person no later than 3 days after release with the Lake County Sheriff's Office at 104 East Erie Street, Painesville. Failure to register, failure to verify residence at the specified times, or failure to provide notice of a change in residence address or other required information as described above will result in a criminal prosecution.
Your Honor, Mr. Thomas is going to speak on Mr. Brown's behalf.
Okay.
Thank you.
Thomas?
Thank you, Your Honor. We would like to ask the court today to impose the mandatory minimums that are required for Mr. Brown. We were at trial. You heard all the testimony. You heard from Mr. Brown himself. In reviewing Mr. Brown's criminal history, he has no prior criminal history of any violence and no prior history of any sexual-related offenses. This is the first time for this type of offense for him. So based on that, we'd like to ask to impose the minimum sanctions. In speaking with Mr. Brown, he indicated to me that he has lost almost everything. He's lost his family. He's lost his kids. He wants to be able to, down the road, have an opportunity to reconnect with his family, specifically with his aunt and uncle in Virginia, who have been very supportive for him, have been in contact with him throughout the duration of this entire case. He does eventually want to be there for his children, be a good role model for his children. They are the most important thing in his life. As indicated, like I said, he's got no prior history of violence or any prior history of any sexual offenses, so we would ask the court to impose the minimum sanctions. Thank you.
All right, Mr. Brown, would you like to tell me anything before I impose sentence in this case?
Yes, sir. Is it okay if I stand up?
Sure.
Try to make it as brief as possible. My apology is not admitting the guilt, but I would like to apologize to the family for the reasons because I should have listened to my treatment team and my mental health team as well of not just moving into anywhere I don't know the environment or anything as well. I should have pretty much knowing what I'm walking into before I go to, to make any kind of decisions, as well as for my mental health and for all the treatment as well as I've been through. Also, as well as being drug free, not being around an environment that has drugs or any alcohol or anything as well. It's not my business, or as well as I'm not a counselor or social worker or anything else to handle other things in the house, or as well as do duties around the house, or take daughter to park, or do any of these things that I was doing at the house. I just feel like at the end of the day, I was in the wrong place for my treatment and also for my mental health. I had to raise as well as my medications around that, and also just it was toxic for me, and I was the monkey in the middle, and I shouldn't have been there in the first place. And just for just for on record, I did not get to see, as well as all the evidence, just me and my phone dump as well before the trial started. My character witnesses, yes, John said it wouldn't have been a good idea, but I did want my character witnesses as well. I did complain about ineffective counsel and conflict of interest as well. My due process, a badgering from the prosecutor as well. Hearsay, it was a lot of that, and it wasn't based on a lot of facts. I feel like it would be, like it was kind of unjust as well as in the trial. No disrespect to the judge or anybody. Also, the prosecutor was improper on saying certain things of finding him guilty on please convict him, just the elements, and quality over quantity, whatever that was, how that was supposed to go. Contradiction in the trial, I did see a little bit of that, but I'm not a lawyer. I did not sign any stipulations for evidence if I had to, and fabricated testimonies, I feel. And with that, also I would like to say thank you, Judge O'Donnell, for the time, as well as for me to get treatment also down the road. That I know you said I would not finish and everything, but I really appreciate that time, as well as that effort that you sent me and gave me that opportunity to get myself better and not wanting to do drugs.
Mulligan?
Your Honor, the state would ask the court to impose the statutorily mandated sentence as you see fit, having heard all of the evidence of the defendant's multiple violations of this 12-year-old child.
All right, I reviewed the pre-sentence report, and I also reviewed the victim impact statement. I sat here and listened to the trial, and there was very compelling testimony from the victim in this case. But if even if you doubted the testimony of the victim, I don't know how you get around the scientific evidence of the DNA. So that scientific evidence 100% corroborated the testimony of the victim, and there's just no getting around that. So, Mr. Brown, you got up and testified on your own behalf, and the testimony that you gave and the explanation for the scientific evidence was absolutely incredible. There's no way it happened like that. And I think, if I recall correctly, the jury deliberated for about 25 minutes. So there wasn't a lot to talk about in this case. So there was testimony indicating multiple times where this sexual conduct occurred, and there were 2 counts in the indictment. They convicted you of both. So there's no, as I sat here and listened to it and reviewed everything, there's no discrepancy about what happened here. Now, whether that was a bad place for you to be or a good place for you to be doesn't matter, okay? You engaged in conduct that you clearly shouldn't have engaged in. And really, as I review the pre-sentence or the victim impact statement, caused a lot of damage to that young lady. So I've considered what you said, what counsel have said, and the PSR and the victim impact statement. I've considered all the provisions in 29-29-11, 29-29-12, 29-29-13, and 29-29-14. On count one, the penalty on this, the statutory penalty is a minimum of 10 years up to a maximum of life in prison. So that will be the sentence on count 1. Sentence on count 2, a minimum of 10 years to a maximum of life imprisonment. And I'm going to run those sentences consecutive to one another. And consecutive sentences are necessary to protect the public from future crime and for appropriate punishment. They're not disproportionate to the